Third-party funded special needs trusts. We'll look at each of those types of trusts individually. They've been permitted in Pennsylvania since 1987 for trusts funded with monies not owned by the disabled beneficiary. Most of the time, they are funded through wills or through what we call inter vivos or living trusts of family members. There's no payback to the Department of Public Welfare because it's not the disabled person's own money. It's somebody else's money. Somebody else's money is funding it. Therefore, there's no need to have a payback to the Department of Public Welfare. When you create these trusts, and by the way, when we create these trusts, we don't put them in the will. We make them in a document separate from the will. We do that for a variety of reasons. The most prominent reason is that a will, as you may or may not have heard, has no legal effect until you die. A will sits there in your safe deposit box or in your firebox or in your file cabinet, wherever you keep it. It sits there and it has no legal effect until you die. You know, it's like spontaneous combustion. You die and all of a sudden this document has enormous significance. But it has no significance until you die because you can revoke it, you can change it, you can modify it, you can amend it at any time prior to your death. So when you look at whether to create a trust, we talked about the situation where perhaps a grandparent might want to fund a special needs trust, so that when we do, if parents come to us with a disabled child and they want to create a trust for that child, we create the trust outside of the will so that it exists today, so that if grandma or grandpa or Uncle Fred or Aunt Louise wants to leave money to the individual with disabilities, there is something in effect now that they can identify and it can go to without any difficulty. So when you are looking to create one of these trusts, and we also call them common law discretionary trusts as well as third-party funded trusts, we call them that because it was a creature of the common law. The courts allowed these to be created in Pennsylvania. It wasn't the legislature, it wasn't Congress. The courts said, we will recognize these trusts in Pennsylvania, and they have our stamp of approval. So they were created by the common law. They are we call them discretionary trusts because the trustee has that kind of discretion, and we'll see. It has to be clearly stated that it's the intent of the settlor to supplement and not supplant public benefits, and that such benefits be considered prior to distribution of any trust income or principal. In the trusts that you see of, you know, the wealthy families that pass it from generation to generation, oftentimes there is mandatory payments of income that go out. The beneficiary will get income quarterly and can get principal, you know, maybe 5% per year, something like that. In special needs trusts, in all of these special needs trusts, they're not the one thing we always tell clients, they're not ATM machines. They don't pass out cash to the disabled person. They do not provide money. They buy things for the disabled person, because special needs trusts are for people who are eligible for typically for SSI, which is a supplemental security income for disability. And in order to get these programs, SSI and medical assistance, you can't have too many resources. There are resource limits and there are income limits. The resource limits are you typically can't have more than $2,000 in liquid assets. In terms of income, to get SSI, you can't have more than about $630 of income under present standards. If you get $1 of SSI in Pennsylvania, you automatically get medical assistance. For medical assistance, the income levels are a bit higher. It's about $900 a month at present for a single individual. But when you start passing out cash to the disabled beneficiary, you're going to lower an SSI check, and you can lower it to nothing. And you could be giving out enough cash that you could disqualify them for medical assistance. So you don't give out cash, by and large, from a special needs trust. You pay for things. You buy services. If they want a TV, you pay the TV place. If they want a computer, you pay the computer place and have it delivered or have them go pick it up. You don't just give cash to the disabled individual. And by the way, sometimes when we think of disability, we think primarily of cognitive disabilities. And that's the primary area of disability that special needs trusts are created for. But there are many people that we represent who are physically disabled, get medical assistance, are cognitively fine, but they just physically can't work. So they're disabled, and they get medical assistance, and we do the trust for them. So it's not just cognitive disability, it's also physical disability. Other factor to be considered in establishing these trusts, the trust should be irrevocable. The trustee must have total, absolute, unfettered discretion to pay or refuse to pay income or principal from the trust. Never instruct the trustee to make monthly payments of cash. Now, the second type of trust are the self-funded special needs trusts, or as we also call them, the payback trusts. They're funded with monies of the disabled beneficiary. 1993 was the start date. Here are the standards, and this, for the self-funded trust, the law is very clear. It's kind of cookbook-like, and you can't deviate from it. It has to be for a disabled beneficiary, just one. You can't do it for multiple disabled beneficiaries. Families that have more than one kid with disabilities, or just more than one kid and want one disabled child to also benefit from it, you can create a third-party funded trust for multiple people. Self-funded, just one.